Good morning. You're Juan Sanchez?
Yes.
And Mr. Sanchez is on probation in cause number 1830854 for the offense of driving while intoxicated, third or more. Was previously in court, entered pleas of true to counts 1, 2, and 3 in that motion to revoke his probation. And there was an unagreed, there was no deal, and I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, I have.
And I have received some objections filed, comment and objections filed by Mr. Franklin. Mr. Nichols, does the state have any objections or corrections to the updated report?
Not to the report, Your Honor.
Okay. And so with regard to Mr. Franklin, specifically, with regard to number 1, that comment in there by the probation officer with regard to that it's unlikely that it was the first time, I'm not really going to take that into serious consideration. So that's not something that's going to make a big difference in what I do today or not do. So that one, I guess if it's an objection, that can be granted. With regard to number 2, which has to do with a note in the records that you were able to look at with Officer LeBlanc asking whether or not a naturalized citizen based on their criminal history could still be potentially denaturalized and deported, and that has some type of race bias. That is also not something that is going to impact my decision, I think, as far as what I'm going to do in the case. I understand your position. Honestly, with the criminal history, which I know is another objection, we'll get to that and what's going on. I don't think it's improper to ask those questions, and I don't see anything else, especially she even put some positive things that he's done in this updated report, so it's not all negative. So I don't think there's a clear sign that there's some kind of racial prejudice or anything like that. So that's overruled. With regard to the fact that his prior convictions are inadmissible hearsay and too remote, in any motion to revoke probation or any case, prior offenses could potentially not be admissible for purposes of enhancement or sentencing in front of a jury. But as far as going into, especially when it's a driving while intoxicated, which requires prior offenses to get where we are, I think it is imperative on me to understand the criminal history, understand when those were, understand the remoteness of some of these, but it doesn't take away from the fact that you have to have those prior driving while intoxicated to get where we are now. And so I'm going to overrule that objection with regard to the prior convictions. Any witnesses today by either party? Does anybody have any witnesses?
I have no additional witnesses, Your Honor.
Your Honor, we previously submitted letters of support.
Yes.
And we believe those are in the record, and the court has reviewed those. I just
Yes.
wanted to note, for purposes of today, that we have filed those. They have been reviewed by the court, and we hope the court has taken those into consideration in considering sentencing as well.
I will, and I did, and let me pull them up again just because I think that's been,
So specifically, they were not admitted for this purpose. They were admitted for bond.
okay, that's right, thank
For
you.
purposes of bond. However, the letters of support, the
same,
information in
sure.
them speak to my client's character and
Yes.
his support by the community.
I see them right here, and I did review them obviously for that, and we'll take them into consideration for this hearing as well.
Thank you, Your Honor.
Anything else?
Your Honor, just in response to the analysis of the court's overruling of the objection, we would point out, as noted in the PSR, there is a substantial time in between the prior conviction and the current one for which he's on
Sure.
probation. And we hope that the court was able to look at that and considered that from 2001 to 2018, there was
Yes.
a major gap. And then by all accounts, by the admission of the probation officer, Mr. Sanchez has had minimal violations, was not a supervision problem, made efforts to be in compliance with probation. And although he did plead true to the current violation, he has shown 5 years of continued compliance. And we asked the court consider the gap in history, the 5 years of compliance, as factors to keep him on probation.
Thank you, Mr. Franklin. Mr. Nichols?
Your Honor, this case was originally pled as an 8-year cap. I'd argued for Penn Diamond at its original sentencing 6 years ago. I'll acknowledge he's been mostly done well on probation except for the new offense and the new violations that are alleged that he did plead true to. And I agree that his criminal history, while somewhat extensive, is rather remote. So I think those factors give the court enough information to make a decision. I am in favor of revocation just because it is another DWI offense, Your Honor. But as far as the length of time, I think the court has enough information to make a just decision on that.
So, Mr. Sanchez, the issue, I understand Mr. Franklin's argument as well as Mr. Nichols. You did have a substantial amount of time where you were able to not drink and drive. The history is old, but then again, you started it up again, in my opinion. You got this DWI, and so you had, there's a couple back in 1995, and then there's one in 2000, and then you had this one in 2018, and now we have another DWI that you have admitted to in another county where you were driving a vehicle without the interlock and under the influence. And at this point, I feel like we're all lucky that you have not, that we're here on a DWI, not an intox assault or an intox manslaughter or something like that. At some point, you've got to figure it out. You're on probation for the same offense. So I'm not inclined, and I don't think it's in the best interest of the community for you to remain on probation. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I am going to take some of the good things that you've done in the length of time into consideration. I had initially marked on this pre-sentence report that I should probably give you the full 10. Mr. Franklin makes some good arguments with regard to the length of time that you went without being in trouble. It looks like you did well with some things on probation, but the main thing, you didn't. And so at this time, I'm going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you a trial court certification. I need y'all to sign this real quick, Mr. Franklin, that shows that this was not an agreement, so you do have some rights to appeal. Once y'all sign that, I'll get tear off that bottom copy for y'all if y'all signed at the bottom. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, then you can talk to Mr. Franklin. And I'm going to go back. I'm not sure if I'd said it exactly properly. I am going to reassess your punishment because you were already assessed a 10-year term. Reassess that punishment at 7 years. And here's that firearm, Mr. Franklin.
Thank you, Your Honor.
This is just going to go, this is to go in the pile after trial, yeah. Let's see. The bottom 2 copies are y'all's if you want to tear those off.
Okay. I think you pressed very hard, Judge.
That's okay, as long as my signature came through, I'm okay, because I get the top 2 with his on it. Give me one more of those. There's 4.
I'm so sorry.
Nope, you're good. Perfect. Thank you. All right, sir, you can go back with the bailiff.
Good morning.
Good morning, ma'am. You're Desiree Kirks.
Yes, ma'am.
And Ms. Kirks, in cause number 24, DCCR 0518, you're charged with the third-degree felony offense of deadly conduct discharging a firearm from February 9th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Kimmler's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year deferred probation, a $500 fine, and you would be required to follow any and all rules of probation. Do you understand what the offer is?
Yes, ma'am.
You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you're found guilty and what your possibilities are or options are if you go to trial. Do you understand?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, and Mr. Nichols, is there any reason to believe that that offer would change or
I
any
don't see
information you don't
reason.
have?
I don't see anything at this point, Your Honor.
So, Ms. Kirks, I want to make sure you understand that after today, I will not accept this plea agreement. So if you change your mind later, you could enter a plea of guilty, but it would be to something different or just open to the court. Do you understand?
Yes, ma'am.
All right, and so we will get it set on the trial docket. Mr. Kimmler will begin preparation for trial.
Okay.
All right, you're free to go.
You got it. Stay in touch with me.
And then on Ryan Hodge, Mr. Kimmler. Good morning. Are you Donnell Coleman? And Ms. Coleman, were you able to get someone hired?
No, ma'am.
Did you talk to some lawyers?
Yes, ma'am.
Who'd you talk to?
I still have Mr. Ross.
I'm sorry?
Mr. Ross.
Uh-huh.
Ross.
Yeah?
Yes, ma'am.
What about him?
He gave me a deal. Like, he shot me a deal because based off of my income, he seems to be exchange.
Uh-huh.
Because my case is picked on that.
Okay. Did you talk to some other attorneys or you were planning on trying to hire him? So what I'm going to do, Ms. Coleman, is have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. Don't leave it all blank or write zeros. Put all any income you have, any bills you have, and then I'll take a look at it. Step in front of the clerk. She'll give you that information. Good morning. You are Ava Musgrove?
Yes, Your Honor.
And in cause number 25, DCCR 0048, Ms. Musgrove is charged with murder, set for trial to begin with jury selection Monday the 29th. And what is the announcement?
So, Your Honor, a couple of things. So, we just recently received an offer, or a new offer, from the state. There is a cell phone extraction that was performed a couple of months ago. It is a voluminous amount of material. We're still reviewing that. So if we could just have one more reset just to finish reviewing that, I think we're close to a resolution.
So why is it on the trial docket then?
Originally, that was, they said they didn't want an offer and wanted to proceed.
Right.
I think it had to do with the theory of their case.
Okay.
So because of this new offer, which we're heavily considering.
So here's what I'm going to do. I'm going to reset it. I'm going to take it off the trial docket. I'm going to reset it 45 days for a review.
Perfect.
And at that point, if there's something that gets worked out, it needs to take place on that day. Otherwise, it will go back on the trial docket and it'll be ready for
Fine.
trial.
Yes,
Is that good, Mr. Nichols?
Yes, sir.
Okay. All right. You can go back with the bailiff.
All right, thank you.
45 days on a review. Jermaine Young, Mr. Burbank, that's Mr. Hoffpower's case. Good morning, you're Jermaine Young,
Yes, ma'am.
and this is 24 DCCR 0916. Mr. Young is charged with aggravated sexual assault of a child. Mr. Burbank?
Last time we were here, we were waiting for some records. I've received some of them. I need to talk to Mr. Hoffman. Can I just have a short recess so that I can see if we can? This is getting old. And
It is.
I know that this court does not want to set it until there's a drop dead trial.
Yes, I just want y'all to visit before court day.
Last week, as I said, but
Okay. Ms. Malfino?
I don't have an update, additional to
Okay.
that. Judge, if Mr.
Patricia
Hoffman
Benton.
ends up being tied up this week, I'm happy to speak with Mr. Burbank.
Okay, perfect. So I'll just do, this will be the last reset. It'll be a normal 30-day reset, give you plenty of time to visit with Ms. Malfino, Mr. Hoffbauer. Make sure you visit with Mr. Burbank before that next court date so that y'all have a plan on what to do on your case when we come back, okay? All right, thank you.
Ron. Excuse me.
Yes. You can just stand right over here on the, a little closer, there you go. Okay, sir, you are Raymond Allen Ryder. And so, obviously, we selected a jury yesterday in this case. The attorneys have come and discussed with me some issues that came up with regard to the case. It is my understanding that you guys have reached an agreement, is that correct?
Correct, Joe. It's correct, Joe.
And Mr. Hoffbauer, you've had an opportunity to go through with the complaining witness and discuss what those issues are, and you're ready to go forward with this, is that correct?
We have discussed it and we explained the situation.
Okay. Then will your client waive the formal reading of the indictment?
We do, Judge.
Mr. Ryder, in cause number 2341597, the state has elected to proceed on the lesser included offense of a Class A misdemeanor indecent assault from December 30th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kelly? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 1-year term in the Jefferson County Jail, but that would be probated for 2 years. You'd be on probation for 2 years. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen? State tenders number 1.
No objection, states number 1.
It's admitted. Is there any evidence that Mr. Ryder is not competent?
It's not, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser included offense of indecent assault. Sentence you in accordance with that agreement to a term of 1 year in the Jefferson County Jail, but that will be probated for 2 years. You're ordered to pay the fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that jail time while you're out on probation. The other side to that, however, is if you violate any condition of probation, you can be brought back into court and you could be facing that sentence that you've already agreed to. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. Is probation? Okay, so when you leave today, you'll need to go straight to the probation department. We'll get you some documents that have where that is so that you can start that process with probation. Obviously, you will also be required to take care of everything you're supposed to in your Orange County case. That was part of, I think, what went into the agreement in this case, and so it's very important that you take care of that and understand that if you don't, obviously you're looking at a revocation there, a revocation here, and everybody on both sides will know what's going on. You understand?
Yes, ma'am.
Mr. Hoffbauer, is there anything else? Do you have a victim impact statement?
Quickly,
Okay. And this is, it's non-registered. Yeah, just go have a seat.
briefly, Judge, we do have a victim.
Sure. So you can come right up here, ma'am. We'll go off the record. I mean, how long? I was about to say that's been 35 minutes. Good morning. You're Kingston Walker? And Mr. Walker, you were previously here and given some time to hire a lawyer. Did you get someone hired?
I spoke to multiple lawyers and I chose a lawyer, but I just need time to forward the payment.
Who'd you talk to?
Burbanks.
Okay, and you're planning on hiring Mr. Burbank?
Yes, ma'am.
All right, so, and you're working?
Yes, ma'am.
Okay, so what I'll do is reset your case about 30 days to give you some time to see if you can get him hired. If you do, just bring that reset notice that you get today to him in his office and they'll tell you what to do. If for some reason it's not going to work out with Mr. Burbank, then I'm ordering you to visit with at least 3 others. See if one of those works out. If fine, great. If not, bring me those names so I know you're trying, okay?
Yes, ma'am.
All right, step in front of the clerk. She'll give you that reset notice. Good morning. You're Tyron Williams?
Yes, ma'am.
And Mr. Williams, did you get someone hired?
Benjamin Jeffries, but I'm still trying to get some money together.
Okay, so you're planning on hiring Mr. Jeffries. Have you made any payments yet or
I
not?
want half of it before he started doing it.
Okay, so what I'll do is reset your case about 30 days. Your case is getting old. It's indicted some time ago, and the offense date was obviously early last year, so you need to try to get him hired if you can before that next court date.
Okay.
If it's not going to work for some reason with Mr. Jeffries, make sure you talk to at least 3 other attorneys, and if you can't hire any of those, bring me those names so I know you're trying, and we'll discuss your options. Okay, step in front of the clerk, and if you'll put Jeffries on there as well, please, thanks. Good morning, you're Marquise Berry, and this is your initial appearance in cause number 25, DCCR 0882. You're charged with aggravated assault with a deadly weapon from April 20th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Are you working?
No, I'm gonna do this. I'm 7 years free.
Did you bring any documents that show you're on bed rest?
Oh, I don't know. I need to do this.
Okay, so what I'm going to do, Ms. Berry, is I'm going to reset your case for about 2 weeks. You need to bring me some documentation from your doctor that says that you're unable to work right now, okay? And then we'll discuss what your options are. Make sure you bring me back that documentation. Are we here next week? Next week's a normal week, right? Yes. I'm going to reset it 1 week. Get that documentation and bring it back next week. Step in front of the clerk, she'll give you your reset notice. And if you'll make that notation as well, thanks.
How you doing?
Good morning, you're Derek Mouton?
Yes, ma'am.
Mr. Mouton, were you able to get someone hired?
No, ma'am, not at the moment. I have spoken to somebody about, I want to say, the next 2 weeks, I have somebody hired.
Who's that?
Miss Brittany.
You're planning on hiring Ms. Holmes, and you can do that within a couple of weeks?
Yes, ma'am, I should be able to do it.
So I'm going to reset your case one more time, a normal reset. That gives you 30 days to get her hired. If you get her hired before then, just bring this reset notice to her so she knows that court date and she'll let you know what to do.
Yes, ma'am.
If it's not going to work out with her, then you need to talk to at least 3 other attorneys and bring me those names when you come back. Okay? Step in front of the clerk. Thank you.
Thank you.
Mr. Chason tested negative for everything, so that's good. Thank you. Yes, thank you. I need your signature, though. All right, ma'am, you're Renisha Chason? And will she waive the formal reading of the indictment?
Well, Your Honor.
And again, we're just going to get a plea on the new indictment, reset the MTRP case, and come back and see where we are with the pre-sentence report. Is that correct?
That's correct.
That goes with that also.
Judge, just to refresh the court's recollection, the co-defendant in this case, who is the, in my opinion, much more culpable defendant, has already pled to TDC time.
Okay, thank you. Ms. Chason, in cause number 24, DCCR 2351, you're charged with the second-degree felony offense of injury to a child, and that's from July 19th of 2024. And how do you plead to that charge? I'm sorry? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand? And it looks like the agreement that you've made is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, states one.
It's admitted. Is there any evidence that Ms. Chason is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, but I'm going to reset your case so that the probation department can do a pre-sentence report. And if that can include an update also on the probation case where the motion's filed, so I can have all that information as well, and then we will come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see y'all back at sentencing.
Would the court consider allowing her to remove the drug patch? It's costing some money that she doesn't have.
Not until sentencing. We're going to keep it on until sentencing. Make sure you keep it on and keep it updated, and then if everything goes well,
When do I come?
it's about 5 or 6 weeks. Okay?
Maybe you excuse me?
Yes, thank you. Good morning. Are you Randolph Fines?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Fines, in cause number 25 DCCR 1154, the state has elected to proceed on count 1 only, and in that count to the lesser included offense of a Class A misdemeanor, unlawful carrying a weapon, from June 29th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Vines is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of unlawful carrying a weapon, sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I feel like this might be one. I don't know all the misdemeanors, but I feel like this is one. Yep. So I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You obviously know this based on what you're charged with, but I'm required to read it. And now I forgot where I was, but lead to charges against you. If you have any questions about what, you should read the document I provided you. I don't know. I lost it totally. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Mr. Rojas.
Yes, ma'am.
You can go back with the
Thank you,
bailiff.
Your Honor.
That's what I get for not reading it. I'm reading it in my head. I don't even know where my copy of it is anymore. I've read it, I've said it so many times. But I can't stop in the middle and then restart. That's not good. Good morning, you're Erica Messina. And Ms. Messina was previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections? All right, ma'am, I'm going to find that you entered your plea of guilty previously, freely and voluntarily. Find that you're mentally competent, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have this conviction on your record. And at the end of the probation period, if you're successful, the case will actually be dismissed. You'll never have a felony conviction. The other side to that is if you violate any condition of probation, you can be brought back into court, found guilty, so you would have the felony conviction, and sent to prison for anywhere in the range of punishment, which is between 2 years and up to 10 years. Do you understand? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am. Thank you.
Thank you.
And you've got Duma Turner. Good morning. Are you Monique Wynn? And this is 24 DCCR 1298. Ms. Wynn is charged with theft of property. And what is the announcement?
So, Your Honor, we were advised, Ms. Wynn, there were thefts that spanned over several counties in which she has been given time in certain ones, probation in certain counties. And so I talked with Mr. Coleman in regards to the time that she has served about getting her credit. Look, she was in custody for a year. And she was recently released in May. So we want to get proof of that credit so that we can give her credit for the time on this case.
Okay, so I'll just do a normal reset. Ms. Wynn, make sure you stay in touch with Ms. Holmes, and then we'll see if we can get your case taken care of at the next court date. Okay? Thank you. You're free to go.